Honourable Member for Don Valley West.
Well, thank you, Mr. Speaker. It is my privilege today to speak on a matter that is very important to both this government and to Canadians at large. I'm talking about respect for communities and, of course, about Bill C-2, the Respect for Communities Act. Over the course of the debate in this House, we have heard considerable detail about the purpose of the bill and the provisions within it. My intention in speaking before you today is to focus on a particular aspect of the legislation, the ways in which Bill C-2 reinforces the respect our government has for Canadian individuals, families, and communities. We know that illicit drug use poses serious risks to public health at an individual level and at the broader community level as well. These dangerous and addictive drugs tear families apart, foster addictions, and destroy lives. The serious impacts that these substances have on those who abuse them are not only detrimental to the user, but also cause serious concern and fear for their loved ones, their friends and families, and those who live nearby, including neighbors and other community members. Illicit drug use also poses serious threats to public safety and public order. For instance, we know that criminal activity results and prospers from the use of illicit substances. They often help organized crime in getting a toehold into our communities, and the profits that flow from their purchase allows these criminal organizations to proliferate. It's for this very reason that Bill C-2 requires that rigorous criteria be addressed by applicants wishing to establish new supervised drug consumption sites. Mr. Speaker, equally important, Bill C-2 gives the people of these neighborhoods, our senior citizens, young families, and the business owners an opportunity to have their say on a matter that has the potential to dramatically impact their community. Canadian families expect safe and healthy communities in which to raise their children. And the Respect for Communities Act will give local law enforcement, municipal leaders, and local residents a voice before a permit is granted for a supervised injection site. Bill C-2 establishes rigorous criteria that must be addressed when seeking an exemption for a supervised consumption site and gives the community members a voice in this process. I congratulate the Minister of Health for putting such a responsive bill before us for consideration. Mr. Speaker, I also want to point out that Bill C-2's genesis is found in the 2011 Supreme Court decision in a case involving a supervised injection site. In that decision, the court affirmed the exercise of ministerial discretion to give exemptions under Section 56 of the Controlled Drugs and Substances Act, or the CDSA. The court also said that the minister must balance public health and public safety concerns when exercising that discretion. The Supreme Court of Canada outlined factors the minister must consider when assessing an application seeking an exemption from the CDSA to conduct activities at supervised consumption sites. These include evidence, if any, relating to the impact of such a site on crime rates, the local conditions indicating a need for such a site, the regulatory structure in place to support it, the resources available for its maintenance, and any expressions of community support or opposition. These factors form the foundation of the criteria that are incorporated in Bill C-2. I would like to bring to your attention to the last of these factors, Mr. Speaker, which states that exemption applications consider, quote, expressions of community support or opposition, end quote. As we've said many times here before, our government believes that input from the community is essential. Embracing the need for consultation is one of the major ways that we are demonstrating respect for Canadian communities, hence the title of this act. Mr. Speaker, the criteria set out in the bill would allow many different voices to be heard and to inform the minister's consideration of an application. The onus would be on the applicant to address all of the criteria. Letters would be sought from various individuals, and let me tell you about these. A letter would be required from the provincial health minister where the site would be located. The letter would need to outline his or her opinion on the proposed activities at the site, describe how those activities are integrated within the provincial healthcare system, and provide information about access to available drug treatment services for people who would use the site. In a similar vein, a letter from the local municipal government would be needed outlining its opinion on the proposed activities at the site, including any concerns with respect to public health or safety. A letter from the head of the police force in that community would also be required, again outlining his or her opinion on the proposed activities at the site, including any concerns with respect to public safety and security. Lastly, letters from the lead health professional, such as the Chief Public Health Officer and the provincial minister responsible for public safety, would be required. This input from both officials and experts would facilitate the Minister of Health's ability to assess an exemption application. Also important are the consultations that the applicant would undertake and report. First, consultations are required with the professional licensing authorities for physicians and nurses in their respective province. Second, consultations are required with a broad range of community groups in the area. The applicant would have to provide a summary of consultations and include copies of all written submissions received. As previously stated, Mr. Speaker, this is the type of input that is necessary and valuable to the Minister of Health. It does not replace the input that individuals may want to submit directly to the Minister. That is why Bill C-2 serves to truly respect Canadian communities through a provision whereby the Minister of Health would give notice that an application has been received. If the Minister posts such a notice of application, members of the public are then invited to provide comments and views on the proposed site for a period of 90 days after posting directly for the Minister's consideration. One cannot overstate the dangers of illicit drugs, which are often purchased with the proceeds of crime and the sale of which often fuels organized crime. In cases where illicit drugs are going to be used at a supervised consumption site, our government believes that every measure must be taken to protect public health and public safety. That is why C-2 proposes putting in place rigorous criteria that must be addressed before the Minister of Health could consider an application for a supervised consumption site where illicit drugs would be used. Mr. Speaker, this brings me to the 6 principles that would be embedded into the CDSA if Bill C-2 were to come into force. The Minister would take these principles into account in balancing public health and public safety when deciding whether or not to proceed, whether or not to grant an exemption for activities at a supervised consumption site. These principles are statements about what is known to be true about illicit drugs, including the fact that illicit substances may have serious health effects. Adulterated control substances may pose health risks, and risks of overdose are inherent to the use of certain illicit substances, and strict controls are required given the inherent health risk that controlled substances may alter mental processes. The use of illicit substances presents a range of health effects for the individual user, from the risk of overdose to negatively impacting dental health to increasing the risk of devastating infectious diseases such as hepatitis C and HIV/AIDS. Malnutrition, life on the street, and dependence on drugs like heroin contribute to poor health and a decreased resistance to disease. Drugs that are purchased on the black market have a high chance of being adulterated. There is no way to regulate their purity, their content, or their potency. This amplifies the undeniable health risk posed by illicit drugs. These principles are essential in that they be taken into account as part of the decision-making process for any CDSA exemption for a supervised consumption site. That is why it is so important that Canadian communities be granted a say before any injection site where these dangerous and addictive drugs are used opens in a neighborhood. A supervised drug injection site would not be created in a residential neighborhood without consultation. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? The honourable member for Ottawa South.
Mr. Speaker, I listened intently to the member's speech as he read it. I wanted to come back to something that he repeated several times. The government was open to cooperating. So if the government is so open to cooperating, then here are a couple of questions. Why, despite this bill being tabled by the Minister of Health, why was it given to an enforced department and committee, that is Public Safety and Security? Isn't this evidence that the government's view of addiction is that it's a criminal act? Secondly, at that committee, many witnesses came for 3 meetings. Many expressed concern that the bill would effectively shut down the current site in Vancouver and make it impossible to create future sites. Amendments were provided by the province of British Columbia, the Chief Public Health Officer of BC, the City of Vancouver, all denied. 60 amendments moved by opposition parties, all denied by the government. And finally, he talks about addiction. I want to put to him, many years ago, someone taught me that addiction is the antithesis of being free. When you're addicted to something, you're actually addicted. So your freedom to choose is severely compromised because you're addicted. So can he help us understand why the government wouldn't be facilitating or helping, particularly in the case, as he mentioned himself, Hep C, HIV infections, $500,000, Mr. Speaker, for every HIV infection in this country, $500,000 to our health care costs.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my colleague opposite. Mr. Speaker, what we're talking about today is the consultative process. Minister of Health has put this bill before Parliament, before committee, for the express purpose of determining, according to the direction she was provided by the Supreme Court of Canada, what are the standards by which a community can have input or must have input, should have input, to ensure that they have the appropriate level of information that they can provide to the minister as to whether or not they want that injection site or consumption site in their neighborhood. It affects businesses, it affects communities, it affects safety. The member asked about why it was put before public safety. In my speech, Mr. Speaker, I spoke continuously about public health and public safety. Those are the key elements that this bill is addressing. This isn't about insight. This bill is about the consultative process that would ensure that there is lots of input for the member or for the minister to make an informed decision given that level of input at a future date on application. Thank you.
Questions et commentaires? Questions and comments? La députée de Montmorency-Charlevoix, au Côte-Nord.
Merci, Monsieur le Président. J'ai une toute petite question simple pour le député. En fait, je pense que c'est important de baser nos lois sur des faits et non sur l'idéologie. Donc, j'aimerais savoir si le député croit que des centres d'injection supervisés sont bien pour diminuer le taux de criminalité, donc travaillent dans ce sens, et aussi s'ils travaillent dans le sens d'améliorer la santé à la fois de l'utilisateur, mais aussi de la communauté environnante. Merci.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker. And I appreciate the member's question, but the question is a disturbing one in that we are not talking about the right or wrong of insight or of that consumption site, injection site. We're talking about a consultative process that would allow the Minister of Health to make a fully informed decision. When the member opposite and his colleagues talk about ideology, their ideology would cause me to be concerned as to the freedom by which they would open consumption sites across the country without appropriate consultation. Mr. Speaker, this study, I sat in committee and heard from many witnesses from a broad variety of professional backgrounds who offered tremendous insight, into what is the right and wrong approach to this. Consultation is clearly the answer to give the minister the right information that she can then proceed and make an informed decision in a community as to whether or not that facility would be opened.